Well, thank you all so much for joining. Once again, today we will be discussing navigating school discipline in New York City. My name is Rohini Singh, and I'll be your presenter today. I'm the Assistant Director of the School Justice Project at Advocates for Children. And just so that everyone knows up front, we will be sharing copies of all slides of this PowerPoint after the presentation, so you will have copies of all the slides. Just one housekeeping note for those that just joined. I will pause a few times in the presentation to take questions. The chat is disabled right now, but you can ask questions through the Q&A feature on your Zoom toolbar. And I'm joined today by Karen here from AFC, who will be monitoring that Q&A feature and will either answer or read out questions that come up when I pause for questions throughout the presentation. So let us go ahead and get started. We have a lot of material to cover today. So first, I will do a quick introduction of Advocates for Children and the work that we do related to suspensions and school discipline. Next, I'll go through the different types of suspensions that students can get in New York City and parents' rights through the suspension processes. I'll go over some legal protections for students with disabilities, and then at the end, we'll cover some key takeaways from the presentation. So first, what is Advocates for Children? As many of you may already know, AFC is an independent agency that protects the rights of all New York City students. We were founded at this point over 50 years ago by parents of students with disabilities, and our mission has really expanded over the years. So we have a number of different services. We have an education helpline. The number is here on the screen, and will also be provided at the end of the presentation. That's open Monday through Thursday, 10 a.m. to 4 p.m., where any parent, student, educator, community member can call with really any education-related question, and our education specialists will help answer them if we can. We also have a number of guides and resources on our website. I really encourage you to go there. The two specific guides and resources that are relevant for the presentation today are our suspension guide and then our manifestation determination review guide, which I'll reference later on in the presentation. We also do a number of workshops and trainings in the community and online webinars now that we're mostly in this virtual environment. And the bulk of our services are free legal services to low-income families. So in the School Justice Project, we do a range of work related to suspension and school discipline. So the School Justice Project helps young people who are facing juvenile or criminal justice system involvement, school suspensions, exclusion from school due to their behavior, those that are either accused of bullying behavior or are targets of bullying behavior. And what we do is we advocate for alternatives to discipline and for behavior supports and services so students can remain in school. We also participate in a number of city and statewide coalitions to reform school discipline policies and procedures and advocate for investments and supports for students. So before we jump into the material today, I just wanted to do a quick introductory quiz. So Karen, if you could launch this poll, that would be great. So these are just a number of statements, and what I'd like you to do is to just mark whether or not you believe that they're true or false. And Karen, let me know when we have some responses, and then I'll go through the results. And I'll give folks just a few minutes. And I could read out the statements. So the first one is the school can call you to come pick up your child early from school. So is that true or false? And the second one is your child needs a doctor's approval to come back to school after being sent home from school. Is that true or false? The third is after suspension, you have to meet with the principal before your child can come back to school. Is that true or false? Number 4 is the principal can call EMS if they think your child is a danger to themselves and others. Is that true or false? And finally, a student can be suspended for a year. So maybe let's see if we could see the results. Great. So let us go through some of these answers here then. So it looks like we had a range of different responses to each question. So let's go over some of the answers. So first, the school can call you to come pick up your child early. So the answer to that is false. And I know we had some folks that said true. So schools are required to provide students with support so that they can remain in school. And if if a school is trying to send a student home early and they're not, following one of the specific types of suspensions or removals that I'll reference later in the presentation, then the school is actually not permitted to do that. The second statement is your child needs a doctor's approval to come back to school after being sent home. And so the answer to that is false. There can't be a requirement or a return that's contingent upon any sort of doctor's approval or doctor's note in order for a student to return to school. Third, after suspension, you have to meet with the principal before your child can come back to school. Again, that is false. And I know there were a few trues there. A few folks selected true. So usually there is a meeting that happens after suspension takes place with the school, either with the principal or the dean or guidance counselor, but that a student's return to school can't be delayed after a suspension in order for that meeting to take place. And so if because of your schedule or the school schedule that meeting can't happen the day the student's set to return, the student is still allowed to return that day. The principal can call EMS if they think your child is a danger to themselves and others. So that's a little bit of a trick question. So yes, the principal may call EMS if they think your child is a danger to themselves and others. However, the principal is first required to try to safely de-escalate with strategies and interventions found within the school building before they call 911 or EMS. But if the behavior poses an imminent or substantial risk of serious injury and the principal deems that they can't handle that behavior in the school, then they are permitted to call 911 or EMS. But there is a specific policy in place that does say that they are required to first try to safely de-escalate a situation before jumping to calling EMS or 911. Finally, a student can be suspended for a year. Some people said false. This is actually true. Up until September 2019, it was actually very common for students to get long-term suspensions, like suspensions over a year. The Discipline Code was actually changed in September 2019, which makes it more difficult for students to get long-term suspensions. But it is still possible for certain types of very serious level 5 infractions. The Discipline Code does provide for suspensions up to a full school year. So why does AFC do all this work related to suspensions and school discipline? So we do a lot of advocacy what we do is we try to advocate for alternatives to school discipline and school suspension because of the large amount of data that exists about the harms of exclusionary discipline on students. So students who are suspended are more likely to miss class, be held back a grade, be suspended again, drop out, or get arrested. And this is what is known to many as the school to prison pipeline. Also really significant is the different disparities that exist within school suspensions here in New York City. So while the overall rate of school suspensions is on a downward trend, what's really significant is that the disproportionality of who is getting suspended it still remains. And so, for example, Black students are 22% of the population in New York City public schools, but they receive 43% of suspensions. And students with disabilities are about 20% of the population of students here in New York City, but they receive approximately 40% of the suspensions. And so they are very much overrepresented when it comes to students that are being suspended here in New York City schools. So let's get into the different types of suspensions and removals here in New York City. And so just a note for folks that might be on the call, that might be interested in charter schools, what I'm going to be talking about here today is just about navigating suspensions and discipline and the rights of parents and students in the discipline process in New York City public schools. That doesn't mean that there are no rules when it comes to charter schools. Charter schools still have to abide by state laws, but the rules and the specific types of requirements when it comes to notices and meetings are a little bit different when it comes to charter schools. AFC does have a guide to charter school suspensions that I can refer you to that is available on our guides and resources page on our website. So first, I want to make sure that folks are aware of and have seen a copy of the New York City Discipline Code. It's known as the Citywide Behavioral Expectations to Support Student Learning, and it's the basis for all suspensions in New York City district schools. It's available on the DOE website, and it should be updated annually, but it has not been updated since September 2019. There are two different versions for grades K through 5 and 6 through 12. Within it includes a DOE mission statement on school climate, a student bill of rights and responsibilities. And as I mentioned earlier, it was substantially modified in September 2019 to include a greater focus on behavioral interventions and supports in schools. Beginning at around page 13 of the code, there's information on progressive discipline, as well as a whole glossary of different types of behavior supports and interventions and restorative practices that schools are expected to use instead of or in addition to exclusionary discipline or suspensions. If you're working with a student that is experiencing behavioral challenges, if your child is experiencing behavioral challenges, it's good to refer to the code and make sure the school's using some of these techniques and not just resorting to suspensions and classroom removals to address behavior. It's written very explicitly that this is required in the discipline code. And if schools are not following some of these steps, then that's a situation where you could call our helpline and we could try to put you in touch with folks to provide you with more support. After the section on different supports for students, there's a section on bullying, supports for students with disabilities. And then beginning on page 25, there's information on different disciplinary responses. Following that, you'll start to see all the different types of infractions that students can be accused of and the possible guidance interventions and then disciplinary responses. These will differ by age and grade, so just make sure you're looking at the correct code depending on the student's grade level. This is just a sample page of the discipline code. This is a listing of different infractions in the code for grades 6 through 12. These are a list of level 4 infractions. And so you'll see this at the top of one of the pages in the discipline code. You'll see the list of infractions. And then at the bottom, you'll see the different types of supports and interventions that a student can receive, as well as the possible range of disciplinary responses for each of those infractions that are listed above. I'm not going to go into this in too much detail. We don't have a ton of time, but I do encourage you to take a look at the code on the DOE's website. We can also include a link to it with a PowerPoint presentation when we send it out after this webinar. So let's go into the different types of suspensions that exist in New York City schools. So in New York City schools, there are 3 different types of suspensions. There are teachers removals, principal suspensions, and superintendent suspensions. So teacher removals, are for behavior that substantially disrupts the education process or substantially interferes with a teacher's authority over the class. It should be noted that within the chancellor's regulations, within the discipline code, it states that every effort should be made to address substantially disruptive classroom behavior using in-class disciplinary responses, along with appropriate supports and interventions prior to implementing a teacher removal. This means that teachers removal should not be the first response to student misbehavior. It's important to note that teachers can only remove the student from their own class. And if the parent asks for a meeting, it must be held within 2 days. A meeting is not required immediately after a teacher's removal, but the school should be calling you or calling a parent if a student is removed from a particular class, and then a parent has the right to request a meeting at that time, and then it has to happen within 2 days. It can be a good idea to request one, especially if there are supports the school can put in place that could help the student. So you might, ask the school to implement restorative practices such as peer mediation or conflict resolution. You can request a behavior contract, at-risk counseling, things like that. But yes, but teachers removals are often happening in schools. And I know that a lot of parents are not getting phone calls when these are happening. So if you become aware that your child is being removed from a particular class for up to 4 days, it's a good idea to ask the school to have a meeting to discuss what can be done in the alternative of a teacher's removal. Next, we have principal suspensions and superintendent suspensions. So for principal suspensions, these are short-term suspensions for up to 5 days. A principal is required to hold a conference prior to the determination that they're going to be issuing a principal suspension, except in some limited circumstances, which we'll go over in a moment. And a written notice is required in this situation. For those of you that work with younger students, you should know that principal suspensions and superintendent suspensions are very rare. For students in grades K through 2, they're not allowed except in very limited circumstances where the student's behavior is repeatedly violent or could cause harm. For students in grades K through 3, principals, often have to get approval before issuing a principal suspension. For superintendent suspensions, these are the longer term suspensions that can last from 6 to 20 days or sometimes over 20 days for some level 5 infractions only. These suspensions require a formal hearing and written notice is required as well in these suspensions. And we'll go over in more detail the rights of parents in principal suspensions and superintendent suspensions in a moment. But it's important to note that no other removals are allowed. And so sometimes you hear about in-school suspensions versus out-of-school suspensions. These are really the only types of discipline that are allowed in New York City public schools. So as I mentioned, for principal suspensions, written notice is required. It must be delivered by personal delivery within 24 hours. It contains a statement of students' rights. It contains the reasons for the suspension, including the date, time, and place of the incident. It includes the date, time, and place of the suspension conference, the period of removal, and the arrangements that are going to be made for alternative instruction. In addition, as I mentioned, prior to a principal suspension being issued, there must be a principal suspension conference. And so students must stay in class until this conference happens, except if the principal is stating that they are some sort of threat of danger. Then they can be sent home. And then the conference should happen very quickly to determine if the principal suspension was justified. The principal is required to attend the conference and decide if the suspension is justified. And at the conference, the parent has a right to present the student's version and question of the event and question witnesses to the event. They have a right to an interpreter, and they have a right to discuss the plan to address behavior. Right, so I'm going to pause here just to see if anyone has any questions related to principal suspensions, teachers removals, or just the discipline code generally. It looks like we have one question. I don't know if this is, okay, it looks like we have one question in the Q&A. It looks like, Karen, are you writing an answer to it?
I was about to, but if you want to.
Okay. No, yeah, I mean, I guess, so the question is, I have a 5-year-old in kindergarten that has ADHD and level 1 ASD with an FBA and a BIP. He keeps getting written up in the OR system, but I feel the school isn't making changes to help with incidents, and clearly the BIP isn't successful. I'm concerned that the school is just letting incidents accumulate and it may lead to changes we aren't looking for. Any advice? So this is, okay, so this is a very specific question. I'm happy to provide some thoughts to this, but this might be something that maybe we can follow up with you directly just to get a little bit more information and see if we can give you some suggestions, since it's a very specific situation. Yeah, but I should just note, and we do go over this at the end, when it comes to FBAs and BIPs, that it is really important that the BIP is being appropriately implemented, that it's being monitored. And so you do have a right to request meetings to review a BIP to make sure that there are effective strategies in place to address behaviors. But we can maybe follow up with you after the presentation to talk a little bit more in detail about the question. And so there is another question here. So please clarify if the principal must hold a meeting prior to making the decision to suspend a student. So yes, so in many circumstances, the principal is required to have the principal suspension conference before making the decision to suspend the student, except in instances where they are claiming that the student is some sort of threat of danger. Obviously, that's, that could be a very subjective standard. And so there's room, if your child is being sent home and being told they're getting a principal suspension and, the behavior was not going to present some sort of ongoing threat, then it is important, and you can potentially push back and say that, you want to have the principal suspension conference before the suspension is actually issued. In some circumstances, in all circumstances, you certainly have a right to appeal a principal suspension. And there are more details about how to appeal suspensions in our suspension guide. But if it is a situation where your child was sent home and issued a principal suspension and a conference did not happen, and the behavior did not involve any sort of threat of danger, then if you appeal it, it's possible that you'll be able to get the suspension overturned and the principal suspension expunged from your child's record. Great. All right, so let's move right along to superintendent suspensions. So as I mentioned before, these are longer term suspensions between 6 and 20 days. The school is required to get approval and call the parent immediately once they get approved for a superintendent suspension. And so typically how this happens is an incident occurs, someone within the school, either the principal or a principal's designee, such as a dean, will do an investigation of the incident. They will gather witness statements, they'll create an incident report, they'll submit this to the superintendent's office, to central, to get approval. And once they get approval for the suspension, then the school is required to call the parent, let them know that they're getting suspended, and then the student is getting a superintendent suspension, and then the parent must get written notice within 24 hours. This written notice should include the specific reasons for the suspension, the alternative school location, details about the hearing, which must be scheduled within 5 school days of the incident, a non-binding witness list who may testify for the school, the parents, and then a list of parents' rights and places to call for help. As I mentioned earlier, we represent students in suspension hearings. We are one of the places that's listed on the suspension notice that parents will call for help for representation at these hearings. It's also important to note that, that technically students are allowed to stay in school before the hearing, except where they pose a continuing danger to persons or property or an ongoing threat of disruption to the academic process. And so in most superintendent suspensions, a student will be assigned an alternative site to attend while waiting for the hearing date. But there are some infractions, some types of suspensions where students might not be removed. So for example, if a student's accused of cheating or stealing or possession of drugs, these are circumstances where, arguably they might not be a continuing danger, and so they should remain in school pending a hearing. This is a sample notice, so you can get a sense of what a superintendent suspension notice looks like. Here you will see information on an alternative placement site. And then at the bottom is the date, time, and place of the suspension hearing and the specific suspension hearing office where the hearing will take place. There are suspension hearing offices in every borough. There's suspension hearing office in every borough. And so typically a student is going to be going to a suspension hearing in the borough where their school is located. Here, this is what the specific charges or the description of the incident looks like on the suspension notice. So it gives you the date, time, and place of the incident and a short description of the behavior. And then at the bottom, you'll see this is what the non-binding witness list will look like on the suspension notice. So what I hope is one of the biggest takeaways from this presentation when it comes to superintendent suspensions is that if your child receives a superintendent suspension and you get a superintendent suspension notice, the next thing to do immediately is to ask the school for the suspension packet. And so the suspension packet is different from the suspension notice. So the suspension notice only gives you, really brief details, or a really brief description of the incident, and not a lot of details, and just information about the hearing. The suspension packet contains all of the evidence that the school will be using at the suspension hearing. And the parent is entitled to the full packet on request. And so schools won't give the full suspension packet to parents automatically. You have to request it. And some schools will actually tell parents they need to wait until right before the hearing, like the morning of the hearing, before they can receive the packet. And that's not true. If there are any issues with getting the suspension packet, you can contact the borough suspension office, and they will direct the principal at the school to turn over the whole packet to you, so you can review all of the evidence. Within the suspension packet, you will find an occurrence report, also known as an ORS report, copies of any witness statements, including a statement from the student, if the student wrote a statement, copies of the records cover sheet, which contains the specific recommendation the principal will make for the length of suspension. An evidence voucher, if any evidence was collected, injury reports, if there were any injuries, video, but only if the school is going to be using the video in the incident. And then any other school records that they'll be submitting during the hearing. So if your student has an IEP, the IEP will be in there, a student's transcripts, their attendance records, teachers' reports, things like that. And as I mentioned, the school is required to give this to the parent before the hearing upon request. And so it's really important to ask for this. I should say also, if you're calling different organizations to try to get representation, most places, including AFC, won't be able to give you an answer about whether or not we can assist with a suspension hearing until we're able to see the full packet. And so it's really important to get this immediately. So this is just a sample cover sheet. I split it onto two sides because it's usually a very long sheet of paper. It has the student info at the top that we blacked out here. It includes an academic summary, a summary of prior suspension history. It's important to look at this, make sure that it's accurate, because this will go into a student's record at the suspension hearing. And then at the bottom of the page, they list different guidance interventions that have been offered. Again, this is also important to make sure this is accurate. If the school hasn't offered any, that's a red flag and something to potentially bring up at a hearing. At the very bottom of the page, the records cover sheet says what the school will be recommending at the hearing. Is it an immediate reinstatement, 6 to 10 day suspension, 20 days or longer? This is really crucial when you're sort of trying to decide your advocacy strategy for the hearing. If the school doesn't give you the records cover sheet, or it's not ready when you get the packet, you can ask the dean or guidance counselor at the school how much time they're recommending for the student suspension. And yes, here at the bottom, you'll see the principal's recommendation for suspension. This is a sample witness statement. And this is a sample occurrence report. Both documents would be included in the suspension packet. And so at a superintendent suspension hearing, you have 3 different options at each appearance. So first, you could potentially ask for an adjournment for good cause. And so either a parent or the school can request an adjournment to gather evidence, contact witnesses, or to request a hearing date that's more convenient. It should be noted that when a parent requests an adjournment, the student stays in the suspension school or the alternate learning center. If the school is requesting an adjournment for some reason, the student should be reinstated to their regular school. And so, if you are not available on that date, or if you want to wait to try to get an advocate or an attorney to represent your child at the suspension hearing, you can request an adjournment. And typically another hearing date is scheduled within 5 days. Excuse me. Another option is to plead no contest. And so by pleading no contest, you're waiving the right to a hearing. And the student is not admitting or denying any of the charges, but the charges are sustained. And so no evidence about the incident goes into the record. So none of the witness statements or the occurrence report will be within the record. But the charge as it's written in the suspension notice is sustained. And then the hearing office will then decide how long the suspension will be just based on that charge. The parent has 3 school days after learning the decision after a no contest plea. If they want to withdraw the no contest plea and decide to go to hearing. And so it's 3 days after the hearing about the decision. It's 3 days after hearing about the decision, either by phone or email, of how long the suspension will be, or 7 days of receiving a written decision by mail. The parent can then withdraw the no contest plea. And so when might be a good time to plead no contest? If the evidence against the student is very strong, especially if a student wrote a written statement admitting to the specific behavior that's in the charge, that's a circumstance where you might want to plead no contest, because it's not likely that you'd be able to prevail at a hearing. If the evidence against the student is particularly bad, there was a fight, or the other student or teacher was badly injured, if you don't want evidence of injuries to go into the record, things like that. You can work out a deal with the school potentially to amend the charges or request a shorter suspension if you agree to plead no contest. And so that's also a circumstance where you might want to plead no contest. And then finally, your third option is to proceed with the hearing. And within the hearing, the hearing is sort of like a mini trial. There are 2 different phases. There's a fact-finding phase and a disposition phase. In the fact-finding phase, the hearing officer will hear the different evidence. The school has the burden to prove the charges, and so they'll hear the school's evidence related to the incident. You would have the opportunity to put on evidence to dispute what the school is saying. And then in the second phase, the disposition phase, the hearing officer will hear evidence to discuss, how long a suspension the student should be receiving if they find the charges are sustained. I certainly recommend, depending on your specific situation, that you try to reach out to one of those advocacy organizations who can either represent you at the hearing or talk through what your options could be, depending on your individual circumstances. So other discipline in New York City schools, it's important to note that you can only be expelled if you are over 17 and you do not have an IEP. Expulsions are very rare in New York City schools. Schools cannot use corporal punishment, and schools can't transfer students without permission. Great. And so I just wanted to quickly go over rights of students when they are on suspension, and this applies to principal suspensions as well as superintendent suspensions. So students are entitled to homework, classwork, exams, and full-time instruction. And this can be either at a student school, a different school, or at an alternative learning center. Suspensions are not supposed to penalize students academically, and so they should be able to have access to alternative instruction while they are serving their suspensions. So what are students entitled to when it comes to alternative instruction? During a principal suspension or while awaiting a suspension hearing in grades K through 8, they're entitled to full-time instruction. And for high school students, they're entitled to at least 2 hours a day. And then after a suspension hearing, all students who continue to be suspended have a right to full-time instruction. Sometimes schools just send students home, for example, in the principal suspension context. This should not happen. If this does happen, you should contact the principal or assistant principal immediately, let them know they're not allowed to do this, and request an immediate meeting if necessary. You can also contact the superintendent's office if this is happening. But there should be some arrangement for alternative instruction while a student is serving a suspension, because students are not supposed to be penalized academically when they're on suspension. Great, so I'm going to pause here for a second, see if there are any questions. Let me see. Okay, so we have one question here. I don't know, Karen, if you, it looks like you're typing an answer to that question here. So okay, oh, we have another. Can you give some background on why 2 hours for high school alternative instruction? So for the different types of alternative instruction, so I should say that typically during principal suspensions, it is they're only entitled for up to 2 hours. If a student is waiting for a hearing for a superintendent suspension, while they're only entitled to 2 hours, they actually typically will get full-time instruction at the alternative learning center. I'm not quite sure. Yeah, I don't know the history of why that is the case, but I do know that that is that's what they're entitled to in terms of the state laws. Okay, so I think we will move on to our next section now. Great, okay, so let me just make sure there were no other questions. Okay, so next we're going to talk about different protections for students with disabilities. So as I mentioned earlier, suspensions are disproportionately imposed on students with disabilities. And this is true even though the law gives extra protections to students with disabilities who are being disciplined in schools. These rights are included in the federal education law, and so they apply to all students in public schools across New York State, as well as charter schools. And so it's important to know that, students with disabilities do have these extra protections, and to be aware of how to enforce them as situations arise. So students with disabilities in the discipline process are entitled to expedited evaluations, a manifestation determination review meeting, which I'll go to in more detail in a little bit. They're entitled to a suspension plan, which explains the different services and accommodations a student will get while they're serving a long-term suspension. And they're entitled to an FBA and a BIP. As I mentioned, I'll discuss some of these things in more detail. There's also a guide to MDRs, or manifestation determination reviews, on our website. That's a great resource to help prepare for those meetings and covers a lot of the information that I'll talk about today. It also has some information on some of these other protections. So first, let's cover, who is a student with a disability for discipline purposes. And so students that have IEPs or individualized education plans are automatically considered students with disabilities and entitled to these protections. Students with 504 plans, similarly, are also automatically considered students with disabilities and entitled to these protections. A third category of students that would be entitled to these protections are students where the school is deemed to know that the student has a disability. So what does it mean that the school is deemed to know that the child has a disability? So if the parent expressed concern in writing to a teacher or an administrator that their child may need special education services, if the parent requested an evaluation, so if an evaluation is in process but hasn't yet been completed and the student doesn't yet have an IEP, if a teacher or school staff express specific concerns about a pattern of the student's behavior to their supervisors, or, and this is a category that only exists here in New York City, is if a child's behavior in school showed the need for special education services, then that student would be entitled to the protections that I just mentioned for students with disabilities. Some exceptions to this are if parents did not consent to evaluations or services, or if an evaluation was conducted and the school district determined the student does not have a disability. But it's important to know that even if your child doesn't have an IEP, if your child's behavior in school did show the need for special education services here in New York City, it might be possible to assert some of these special protections in that specific case. So first, like as I mentioned earlier, students with disabilities have a right to expedited evaluations. So suspended students must get expedited evaluations if a parent's requesting an initial evaluation at the time of the suspension, or as I mentioned, if the school is deemed to know the student has a disability, then these evaluations must be done within 15 days of parental consent. And then after the evaluations are completed, the school must hold the IEP meeting no later than 5 school days after completing the expedited evaluations. And until the evaluations are completed, the student stays in the educational placement determined by the school district, which can potentially include the alternate learning center or suspension site. For students that are considered deemed to know, a student has to be treated with as though they have a disability with all the legal protections of a student with a disability, meaning that schools have to hold a manifestation determination review meeting prior to the IEP meeting using whatever information they have available. And I'll discuss some of these protections in a moment and get into detail about what an MDR is, because I know I haven't covered that yet. But it's important to note that the suspension process can be an opportunity to get evaluations and get an IEP in place in a shortened timeline. And so typically from the date of consent, it's 60 days. This will shorten it to the 20 school days between the time you request the evaluation and the IEP meeting. Great. So what is this manifestation determination review meeting that I keep mentioning? So an MDR is a meeting to decide if the student's behavior was caused by the student's disability or was a result of the school's failure to follow the student's IEP or BIP. And this is a meeting that typically takes place in the school. The parent it must be invited and present at this meeting. And the team will then decide if the behavior is a manifestation or if it's not. If it is a manifestation of the student's disability, then yes, and the answer to the question is yes, then the student returns to school and cannot be suspended. And the school must do a functional behavior assessment and behavior intervention plan, or an FBA and a BIP. If the answer is no, then the suspension continues and the school must create a suspension plan, which, as I mentioned before, is a list of the accommodations the student will receive while they're serving a long-term suspension. And the school can then consider whether or not they should be doing an FBA or a BIP. If during the MDR, school officials or the team identifies deficiencies in a student's IEP placement, or even just in the implementation of the IEP, they must take immediate steps to remedy those deficiencies. And if the parent disagrees with an MDR decision, they can request an expedited impartial hearing request to appeal it. The hearing, as I mentioned, is done on an expedited basis, and so it's typically scheduled within 15 days. It's important to note, and we at AFC attend a lot of manifestation determination review meetings and will advocate for parents at these meetings. It's important to note, sometimes schools have a misunderstanding about what this meeting is about. And it's really important to highlight that it's not about the fact that, that students with disabilities can't be held accountable for behavior, or that there are no consequences for different types of incidents or actions, but it's that students with disabilities should not be punished and should not be excluded from school for behavior that is part of their disability or a manifestation of their disability. Instead, what they should be receiving is supports and services to try to remedy that behavior. And so when must the school hold an MDR? So the law says that an MDR must be held where there is a disciplinary change of placement, which is defined as 2 or more suspensions or removals, where the removals add up to a total of 11 or more days in a school year. And the principal determines that there's a pattern of removals. If there are 11 or more school days in a row, or in New York City, if a student is suspended for 11 or more days within a 40 school day period. This can get kind of confusing. It's really important to keep track of the number of days your child has been either removed or suspended, so that you know when an MDR should happen. In New York City, if a school is properly inputting the different removals and suspensions, the system should notify a school when they have to hold an MDR. But of course, it's really important to keep your own records to make sure that you are keeping track of the different removals and suspensions, so that you can request an MDR or prompt the school to do an MDR if they are entitled to one. And so, in some circumstances, it'll be very clear if it's a superintendent suspension and it's 11 or more days in a row, then they will automatically be entitled to that MDR. But in this, in the circumstance where it's 11 or more days within 40 school days, or within when you have to determine if there's a pattern, that's where it gets a little trickier, and it's important to keep track of the days. So for example, if a student gets a principal suspension on December 1st for 1 day, a principal suspension on December 13th for 5 days, and then another principal suspension for 5 days on January 15th, the school is actually required to hold an MDR before issuing that third principal suspension, because if they did issue it, that would mean that the student would be removed for more than 11 school days in a 40 school day period. And so at an MDR meeting, the team is required to review the student's IEP, their FBA VIP, evaluations and teacher observations, occurrence reports, any records submitted by the parent, and any other information. This can include, other provider reports, medical reports, school progress reports. It could include letters of support from outside therapists, like a listing of a student's diagnoses, things like that. If there aren't a lot of behaviors listed on a student's IEP, but a student sees an outside provider like a therapist or a mental health provider that does have documentation that a student exhibits a certain type of behaviors, it could be, it's a good idea to submit those to the school prior to the MDR so that they can review that material and incorporate it into the MDR when discussing the student's disability. This is the worksheet that the DOE follows at MDR meetings. There's a link to it found within our MDR guide on our website. I would definitely recommend that you review this worksheet before you participate in an MDR meeting and try to answer the questions as a way to prepare. Some tips for preparing for MDRs: review all of a student's documents. Make sure the student is getting all their services on their IEP. Make sure that the school is following the different intervention strategies on a student's BIP. Find out if, try to assess if, maybe if a student is entitled to a paraprofessional, maybe that paraprofessional wasn't there at the time of the incident, things like that. Some tips for, asking outside providers to participate. Outside providers could either call into a meeting or join a meeting in person if it's happening in person, or they could potentially write a letter. We often will try to get outside providers to write letters of support for MDR meetings. They can explain, how they know the student and for how long, explain what type of services they provide, go over the list of documents that he or she reviewed before writing the letter, if any. They can describe any similar incidents that they know about, if any, and state if they believe the behavior was a manifestation of the child's disability, and explain why. When you're reviewing, a student's documents or your child's documents prior to an IEP, prior to an MDR meeting, excuse me, it's good to focus especially on social emotional functioning and behavior concerns, and really pull out and highlight, circumstances where a student acted in similar ways to they did to the underlying incident, because then you can really point to that language and point to those instances and to make that connection why a student's behavior is a manifestation of their disability. Great. So that was a lot of material there. Let me see if there are any questions here. All right, let's see. It looks like we have 2 open questions. Oh, so who is on the team that makes this decision? So for manifestation determination review meetings, it should be a team of obviously the parent. The parent can bring an advocate or any outside providers. The only required member of the team is someone that has knowledge of behavior, essentially. So someone who's able to interpret a student's behavior. It's typically, it could be a school social worker, it could be a school psychologist, but it has to be someone that has some sort of training on child behavior, essentially. And so, the required member can't, unless that person has specialized training, can't really be an administrator. But yeah, so that's the only required member on the MDR team. Typically, we'll also see a students teachers there, guidance counselor, as I mentioned, probably a social worker, folks that were there at the time of the incident, and then usually an administrator is also there as well. As you can tell, I mean, it's often that parents will feel outnumbered at MDR meetings, which is why it's good to invite outside providers that are working with your child, if there are any, who can speak to the behavior. Let me just see if there are any other questions here. So do you have any statistics related to how many MDRs are held and how many are yes? The yes behavior was a manifestation of a student's disability, and how many were found to not be manifestation? If so, what do the demographics show? So we do not have, and I know this question was actually submitted ahead of time, we do not have any statistics. I do not have any statistics. I believe this information would probably make a good freedom of information law request, a good FOIL request. We did have a class action suit against the DOE regarding MDRs, which recently, I think, I mean, maybe not recently, or maybe around 3 years ago now, ended, and because they complied with the terms of our settlement. And so I believe we were getting maybe some data through that, but that data is not publicly available. That data is not publicly available, and we certainly don't have any recent data. And so I think I would love to know the answer to this question. I think this would make a really good FOIL request for the DOE. All right. And then last year, not a question, but a note, our office consults DSM manual to offer evidence to MDR committee linking a behavior to a student's disability. Yes, so we do this as well. And this is a really great tip for parents that it might be going into an MDR meeting. Oftentimes, even though there is a required member who should have information and know information about different diagnoses and disabilities, sometimes they don't know, and they don't have an understanding of how different diagnoses will manifest within students. And so bringing a copy of the DSM that shows your child's diagnosis and shows, you know, the different ways it can manifest can be really helpful in getting the team to link your child's disability with the behavior. Great. All right. So then quickly, just 5 school discipline takeaways here. So as I mentioned, you know, schools should try to help students before suspending them. They're actually required to in some circumstances. The notice must be in writing, both for principal suspensions and superintendent suspension. Ask for a principal suspension conference if your child is being issued a principal suspension. In some circumstances, it's required before issuing the actual suspension. Always get the suspension packet. So the notice is different from the packet. So please always ask for the suspension packet if your student's getting a superintendent suspension. And then, as I mentioned, when it comes to alternative instruction, there's no out of school suspension. So students should have some sort of arrangements for alternative instruction when they are serving a suspension. And then just some wrapping up reminders. I believe that we are going to be launching a poll now with our survey, our feedback survey. If you need help, you know, please ask. We're open. You know, you can call our helpline or email us. And that is all that I have here today. I am going to actually, I think, once we get the feedback survey results, we can turn off the recording and I can stay on just for a few minutes if folks have other questions. Let me just see, I see a question has popped up. Oh, where can we read more information about the lawsuit that was filed about MDRs? You can find that information on our website under litigation. The lawsuit is called EB. And yeah, there should be information on that on our website. Great, I see another question coming up. So when an infraction can either result in a principal or superintendent suspension, what factors are considered to nudge the suspension into a superintendent suspension? For example, level 4 infractions can be either principal or superintendent. Why would it go to a superintendent suspension? This is a really great question. I mean, these types of determinations are made, by the principal's designee, the dean. For a lot of different infractions, there is a range of disciplinary responses. You'll see that in the discipline code. And so there's room for advocacy there. If your child if the school is threatening a superintendent suspension, there's room to try to get them to advocate for a lesser disciplinary response. And it's important to note that actually in the discipline code, it outlines, the DOE's theory of discipline, which is progressive discipline, which essentially means that you should not be jumping to the most significant consequence before, which is a superintendent suspension, before trying out some of either supports or interventions or some of the lesser disciplinary responses. It's hard. I don't know, because these decisions are made on the principals, like on the school level, it's hard to say like what might push it from a principal suspension to a superintendent suspension. But yeah, I mean, I think like in certain circumstances where there's injuries, where there's a weapon involved or things like that, I think that we hope that schools are really trying to use progressive discipline and to not just jump to the highest disciplinary response, but it is something that we do see often. And that is a determination that's sort of made, like how you want to categorize behavior and how you want to charge a certain student, that decision is made on the school level. So that doesn't directly answer your question, but I hope provide some information that could help advocate that could help you when you're advocating in that circumstance. Great. So I think we covered all the questions. It is now 4 o'clock, so we are out of time. Feel free to email us or call us if you have any further questions. Thank you all for participating, for joining us today.